Hi, I'm Loren Locke. I'm an immigration attorney in Atlanta. Today, we're talking about whether it's easier to get an EB1A I-140 petition if you're already in the U.S. compared to if you're outside of the U.S. The short answer is maybe. If you're already in the U.S., that could facilitate working with an attorney, gathering your stuff, probably means more of your background materials are going to be in English and going to be in the U.S. That can make your case more straightforward. For example, if you're trying to show that your high salary is one of the factors, one of the criteria that make you qualified for the EB1A, then it sure is handy when you've been earning your money in dollars and you can compare it to the metropolitan area occupational wage data where you live in the US. It's a lot more complicated if you're trying to say, oh, I am earning a high salary, but my salary's in some denomination that USCIS doesn't understand, in some country where maybe the wages are lower than the US. So if you even translate the value into US dollars, it doesn't strike them as impressive. It's much, much harder to convince the USCIS that you are highly paid if you are trying to use data that is not from the US. So that's like a practical reason that maybe your case will be easier to pull together and win if you're here. The other big factor is that once you win, it doesn't give you the right to immediately live and work in the US. You still are going to be waiting outside the US until your priority date is current. Even if your priority date is current, you still have steps that you have to do. So if you are already in the US, you can continue with the non-immigrant status that you have. You may already be working, and you get to file for your green card by an adjustment of status application in a lot of circumstances. So that means you just ask USCIS, will you change me from my non-immigrant status, maybe H-1B or L or O or whatever it is, into a green card holder, a lawful permanent resident. If you're outside of the US, you cannot adjust your status because you don't have a status to adjust from. Now, one thing to think about if you are in the US and you are in a status that does not fully allow dual intent. So I'm talking every non-immigrant status except for H and L. If you are an F1 student, if you're an O1 alien of extraordinary ability, if you are in any of those, I call them gray area statuses that are not a non-immigrant status, they're, DACA, TPS, you're seeking asylum, you were paroled in, anything like that, then you cannot just simply adjust. If you're in a non-immigrant status like F1 or O1, you are in status, you are allowed to file for adjustment of status, but you need to be careful because you do not have dual intent. You are not allowed to come and go while your adjustment of status is going on until you get advanced parole from the government. And sometimes the government takes forever to issue advanced parole, which is that travel authorization to travel internationally. Sometimes they take so long, you have your green card before they look at your advanced parole application, and then your advanced parole application becomes moot. It is tricky to wait 90 days to file your adjustments from your last entry. And then on top of that, wait an indefinite amount of time until either your green card is approved or your advanced parole is approved and you can resume traveling. Best case scenario, if you are extremely lucky, your adjustment of status is going to take a couple of months. Worst case scenario could take well, first of all, I guess it could be just never approved, right? That could be the worst case. But worst case where it still ends up working, it could take a couple of years. Most people are going to be much closer to the couple of months than a couple of years right now in the middle of 2025, but we don't know how things are headed. Right now, a lot of people are still getting through without getting called in for an interview at a USCIS field office. If you do get called in, it typically adds a lot of time because then you're jockeying with everybody who has to come to USCIS in person for a limited amount of face time with the officers who work there. So you can run into just a big delay there. So is it easier from inside the US or outside the US? For the a smooth life experience. Typically, it's going to be easier if you're here and you don't need to travel. Then you can do adjustment. If you're here, but you have to depart and do immigrant visa processing, or you're outside the US and you've got to do immigrant visa processing, then after your I-140 is approved, there are additional things that have to happen that are a little bit out of your control before you can just show up for your green card interview at the consulate. So, all things being equal, if you could be here in a non-immigrant status, great. If you can't, it's still possible. If you're thinking about this and you're outside the US, definitely consider if you want to get an O1 visa first, come in and work as a non-immigrant, and then pursue your EB1A. Thanks.